we're looking forward to Chief Judge Hamilton's welcoming remarks, which are going to come up shortly. I want to thank the academics for doing just a wonderful job of starting things out. And, you know, as a personal observer of the relationship between Judge Whyte and all three of these universities, he's been a true contributor. You know, he's taught classes at Stanford and Berkeley and Santa Clara. I know he's participated heavily. He's on the board there. So he gives of his personal time. As Professor Murgis says, when people aren't watching, he's coming to teach a seminar for 10 students. So it really is an impressive thing. But right now, I'd like to call Judge Graywall up to introduce Judge Hamilton, and then we'll get going with the visiting judge panel.
Feels a bit like a judicial wedding, doesn't it? And I'm not sure if I'm the mother or the father of the bride, but I'll happily play both of those roles as needed. To formally bring our session to order, it is my privilege and pleasure to introduce the Chief Judge of the Northern District of California, Phyllis Hamilton. Judge Hamilton, of course, is no stranger to this audience and is, of course, very accomplished in her own right. For today's purposes, I think it's important to recognize one of Judge Hamilton's most significant accomplishments, at least in my view, which is that she has had the distinction of serving as a judicial colleague to Judge Ron Whyte since the very first day he received his commission 24 years ago, 1992. With that, Judge Hamilton, thank you.
Well, first of all, I want to apologize for my tardiness. I was supposed to be here to welcome you before the program got started. And as it turns out, it probably is okay because the professors that you just heard from illustrated all the points that I wanted to make about my colleague and friend, Ron Whyte. I'd like to first start out by thanking former colleague Paul Graywall, Ed Reines, and all the others who helped put together this symposium to honor our departing colleague, Ron Whyte. I couldn't think of a better way to show respect for the intellectual giant that Ron Whyte is, other than an intellectual symposium on a subject that comes to mind with the mere mention of his name. How fitting is that? I also want to thank the other institutions, the Stanford, Berkeley, and Santa Clara Law Schools that are sponsoring this program, Federal Bar Association, and all the law firms whose names are mentioned on the back of the program. The judges of the Northern District of California are, first of all, very sad that we're going to be losing Judge Whyte as a colleague soon, but we're so pleased with all of your willingness and enthusiasm for celebrating him in the way in which you've chosen to do so. Just a little bit about Judge Whyte. I understand that there was not a formal introduction, and there might be one or two people here who don't know all of Judge Whyte's history. After graduating from USC Law School, Judge Whyte spent three years in the U.S. Navy, JAG Corps, and that was followed by 18 years of service in private practice in San Jose before he was appointed to his first judicial position, and that was on the Santa Clara County Superior Court, where he served for only a few years before he was tapped for the District Court for the Northern District of California, holding down the fort in our San Jose division. With his mathematics background, which you've heard about, and his intellectual curiosity, his proximity to all of the exploding technology in Silicon Valley, it's really no wonder, if you know Judge Whyte, that it didn't take long at all for him to evolve as a leading expert in patent and technology litigation. Now, all of you know, because you are practitioners in our district, the professors have all made mention of the fact that Judge Whyte is the intellectual force behind our local patent rules, our model protective orders, our model jury instructions. These models, instructions, and rules now serve as exemplars and are followed by judges and practitioners all over the country. The judges on the Northern District bench, including myself, who've been with Ron throughout the entirety of his career on our bench, and all of you practitioners. We all cut our teeth, so to speak, on the rules and procedures established by Judge Ron Whyte. And how fortunate we are to be in an environment in which something as dense as patent law can be, for some of us, was made more comprehensible and accessible by all of the innovations created by Ron Whyte. And I was very pleased to hear the examples from Judge Whyte's opinions, both as a district judge and when sitting on designation, by designation on assignment in the Ninth Circuit Court of Appeals and the Federal Circuit Court of Appeals. He has really contributed to the emerging body of patent law as well as patent case management, which is so important for trial judges. But as the last professor mentioned, Judge Whyte is not just a patent judge, although over 400 patent cases certainly puts him within that category. But as a district court judge, Judge Whyte is a generalist. And the other day, I called our IT department and said, you know, I'm really interested in knowing how many cases has Judge Whyte presided over during his 22 years on our court. And you will probably be as surprised as I that Judge Whyte has presided over more than 7,000 civil cases and more than 1,000 criminal cases. And which, with each of these cases, and granted, even with 400 and some odd patent cases, IP work is not the majority of the work that we do on our court. Although in San Jose, it certainly is a big part of the judges' jobs. But it's not the biggest part. The biggest part is everything else. And Judge Whyte has brought the same care and thoughtfulness to all of his cases, not just the IP cases. And he's always strived for transparency and practicality to all aspects of federal litigation. At heart, Judge Ron Whyte is a teacher. He's always willing to share his knowledge, skills, and experience with lawyers, students, law clerks, and us, other judges. And his generosity is reflected by some of his extracurricular activities. In addition to always carrying a substantial caseload, even as a senior judge, Judge Whyte has been involved in activities such as his service as Dean of Santa Clara's High Tech Advisory Council. He served on the Executive Committee of the Santa Clara Inn of Court and as a member of the National Jury Instructions Project. His law clerks, I just call them up and say, what's your impression of Judge Whyte serving in that capacity? And his law clerks say that Judge Whyte, not unexpectedly, is always patient and polite, but he's got this searing intellect. When he asks somebody from the bench during a hearing, why do you care? It's meant to focus the parties on the heart of the dispute, on what really matters. And one other interesting fact I found out about him is not only is he known around the San Jose courthouse for his thoroughness and his discipline, he's also known to have regularly showed up for exercise routines that the San Jose court staff calls the daily planking. I thought that was interesting. But anyway, we mustn't forget that in addition to being a towering intellect, Judge Whyte is also a kind and humble person. He is respected and loved by all of his colleagues. You couldn't find a more generous colleague than Ron Whyte. He's always willing to do more for the court. He never complains, and for almost a quarter of a century, he's anchored the San Jose Division of the Northern District of California. All judges, no matter what division, rely upon Judge Whyte for his advice and guidance, and he's earned the reputation as the dean of the Silicon Valley bench. And I, for one, cannot fathom what our court's going to do without him.
Thank you, Judge Hamilton, for wonderful remarks. In terms of the schedule, we have the visiting judge panel, which I'll talk about in a moment. Then we're going to have lunch, which will be a buffet. We're not going to be taking time off. We're kind of compressing things. There's so much to say about Judge Whyte. We can't waste a moment. We're going to have an interview where Judge Graywell is going to interview him afterwards. We'll introduce that later, but just so that you have a sense of what's coming. So at noon, get ready to get your lunch, get back to your place, and we'll kind of resume as we are now. The next panel is going to be moderated by Sonal Mehta, who's been a long-time colleague of mine, and someone who I couldn't think of a better person to moderate this panel. I know she's, in the quiet of the office, she's often talked admiringly of Judge Whyte, so I thought she'd be a particularly appropriate person. Sonal?
Thank you, Ed. So today we have 3 judges that are visiting us from all over. I'm going to start to my immediate right, Judge Guilford from the Central District of California. Then to his right is Chief Judge Stark from the District of Delaware. And then finally from the Southern District of California, Judge Benchavango. And what I thought we would do is start with each of these 3 judges from different places talking about the impact that Judge Whyte has had on the way they think about cases and patent law and being a judge. And then in the spirit of cross-pollination of ideas, which Judge Whyte is obviously a champion of, I couldn't let them go without digging into some substantive issues on patent law. So we'll dig into Section 101 and some other substantive questions as well. But let me start, Judge Guilford, with you and ask if you would give us your thoughts on what Judge Whyte has meant to you as a judge.
Well, to begin, as the previous panel said, it's an honor to be on a panel honoring you, Judge Whyte. You have meant a lot to me. I became a judge 10 years ago, and you have inspired me and instructed me in numerous areas. And so on behalf of the judges of the Central District of California, I send my greetings. I have been on a lot of programs in this room, and I've never seen it more crowded, so I think that says a lot. So again, it's an honor to be here honoring you. And from the Central District, one area where you have particularly helped me is the area of local rules. Our Central District does not have local rules. I wonder if the president might temporarily appoint you to the Central District. So you could lead the way on that, as you led the way in the Northern District. And I sort of have tried to lead the way in the Central District. And of course, step 1 was to look at the Northern District rules. You may or may not know, those of you out there may or may not know, that a good number of judges in the Central District simply say the Northern District rules will apply. And I think that speaks well, particularly given the rivalry between the Northern District and the Central District and the Giants and the Dodgers and all of that. So you are indeed respected, and I did look at historically the work you did on the local rules, as I've been an advocate for local rules in the Central District, and that has helped a lot. And of course the jury instructions as well. I was a trial lawyer for many years, and the previous panel noted that you are a trial lawyer's judge. And I aspire to be that too, and I think the rules reflect that. And so those are a couple of areas where I've appreciated your good work.
Judge Stark?
Sure. Well, first, I want to thank former Judge Graywell for inviting me to be here, and to paraphrase what he said, I'm just thrilled to be at this wedding. This is only the second time I've had the good fortune to be on the beautiful campus of Stanford University, and I think I would have accepted an invitation to any wedding of any kind just to be here, but it is, of course, particularly a real pleasure and honor to be here to help all of you honor appropriately Judge Whyte. I may or may not have literally first met Judge Whyte in New Jersey. Professor Manel and I were trying to remember whether or not you were physically present in the room when I was first introduced to concepts of patent law, which are about 10 years ago. I attended a session that Professor Manel was putting on for the judges in New Jersey, and I was a newly minted magistrate judge who didn't know a Markman from anything, and I heard that this session was going on over in New Jersey, and I found my way there. And I think you may have been there, but if you weren't there, then I have learned today that you were there very much in spirit, because what I was taught and what I learned and got me off hopefully on the right step in learning how to manage patent cases, all I understand initiated with you and through Professor Manel and others. And I think that is just one small illustration of the impact you've had. Now, I have had the great fortune of meeting you a couple of times, including serving on panels like this with you, and we've had occasion, and I've enjoyed it each time, to talk about issues related to patent case management. But one comment that I heard you make is one that I think about a lot, and it is illustrative of the type of, I think, deep question about what are we doing when we're handling patent cases that some of the academics mentioned. And I don't know the answer to it, but I remember being on a panel with you, I think it was in Delaware, because among other things, you've been very generous with traveling and attending these conferences and promoting the cross-pollination of ideas among judges who handle cases like this with some regularity. And I believe I recall you saying something to the effect of, you thought oftentimes perhaps if a case was well sort of pre-tried and Markman lived up to what it was intended to be, and discovery went well, and the lawyers and the clients were all acting in good faith, infringement would maybe, in the large majority of cases, be something that could be resolved on summary judgment, that everyone should understand how the accused product or device works, and so there shouldn't be a need for trials. And maybe I come from a district that has a different tradition, my experience has been different, but I thought it was such a thoughtful, I mean, sort of deceptively simple sort of insight and question, and it's one that I have occasion to think about a lot, and we got to talk about it a little bit, and I hope, despite your retirement, we'll have occasion to talk about issues like that and others going forward. So thank you for all of that.
And Judge Benchavenko?
Well, I kind of crashed this wedding. When I saw the flyer for it, I just signed up to come and attend, and then Paul reached out and asked me if I would represent the Southern District and be on the panel, which I was just really pleased to do. And on behalf of all my colleagues in the Southern District of California, we'd like to thank you, Judge Whyte, for all your contributions, particularly the field. And the patent pilot judges are eternally grateful for the work that the Northern District, led very much by you, did in the case management area in patent cases. It inspired myself and the other 4 judges in our district who are patent judges to want to take on that role, because it gives us the groundwork for managing those cases. And when we wrote our local rules, we certainly first and foremost looked to the Northern District and adopted them almost entirely, and everyone still continues to tweak and work, and I know the Northern District does too, and we always appreciate your leadership in that area. I was thinking about when you were putting up cases that Judge Whyte wrote, and you know, when we get briefs from lawyers and they cite to district judge decisions, they're not precedential, they're persuasive, hopefully, for your case. And, you know, frankly, there's very little about the fact that there's a published opinion that you can cite that in and of itself makes it meritorious, because your opinions get onto Westlaw because your law clerk is industrious to send them in, and whether they make the F's up is just a random thing. There's no merit panel reviewing them. So the fact that someone cites an F's up opinion to me in and of itself is not particularly like, oh, okay. So I look to where it came from, and if it's a patent case and it came out of the Northern District, and particularly if it's a Judge Whyte decision, I take a lot of comfort in looking at the analysis there and thinking, okay, that is, I'm gonna guess, very well reasoned and thoughtful in applying the facts to the law and giving me some guidance as to how I should look at the facts in my case and apply them to the law and the tests that the Federal Circuit has laid out for us to use. And so I find, you know, when I'm looking at authority, you know, like my friend Leonard here or Judge Guilford, those are helpful. Some maybe not as much, but Judge Whyte's are always, always at the top of my list to go, that will be persuasive to me.
So it wouldn't be a room full of patent lawyers if we didn't talk about Section 101. So I'm going to start there. We're going to talk about other things too, I promise. But the first thing I wanted to ask our panelists was, are you following the 101 opinions from the Federal Circuit and from other district courts? And what do you make of the law on Section 101 right now? And I'm going to start with Judge Guilford, and then we'll move down the line again.
Well, yes, indeed, I'm following it. Alice, Where Art Thou Going was a song I learned as a kid, and it still seems to apply. And I just love to read decisions from the Federal Circuit and from my district court colleagues to see how they are struggling with the two steps. And, you know, ultimately, in reading all of these decisions, and there's a lot of them, I think you recently had one, what was it? It was...
You may know better than I do.
There you go. And
Thank you for that.
When I read it, again, it's interesting to see other district judges struggle with it and then to see what the Federal Circuit does with it. And when you think about it, in step one, it really is taking a different set of facts and ultimately deciding if it's abstract. And I actually think the more I read a factual scenario and see what the district court judge did with the issue of abstract, and then see what the Federal Circuit did with abstract, it's building up my factual basis, which maybe helps me predict in the future, in a case of mine, whether something will be deemed abstract. Actually, what's going on is I'm inserting into the CPU between my ears these factual patterns and then predicting abstract. I actually wonder if we could come up with a program that would take the different factual scenarios, the decision whether it was abstract or not, put that into a computer and make a prediction as to whether this fact, and then I wonder if that would be patentable and if that itself would be abstract. So I do think it's helpful to read these cases to get the underlying feel. At times it's also interesting to read my fellow district judges struggling with that and occasionally getting slapped down by the Federal Circuit and occasionally getting elevated by the Federal Circuit. But I do think reading the different factual scenarios helps me be a better judge. And a little plug for the patent pilot program. I think one of the advantages of that is, as a patent pilot program judge, I'm getting more cases. And I think the more input I get, the more reliable my output might become.
So I won't admit and out myself here to say I don't read my district judge colleagues' 101 opinions, but I will say there are a lot of them, right? All of us know that. So if I were to try to read all of them, it would take a great deal of time. And because I'm facing this way and there's a window, I have the advantage of knowing that the chief judge of the Federal Circuit just walked into the building. So maybe I'll answer quickly where I think 101 law is. No. What I can say, we in Delaware, we're getting a lot of 101 motions, probably more than even initially when Alice came out. But I think to the extent you do look at our opinions, and I'm more familiar with the ones coming out of our court, I've noticed unofficially a trend that they're getting shorter. And I think that tells you something, you know, as we've gotten more data points from the Federal Circuit. I think that has made, while it's a difficult area, it's made it a little bit easier to apply to new fact patterns, and that may be reflected in our ability to more succinctly address the issue. But beyond that, and now a Federal Circuit judge has just walked in. Hello. Welcome.
Perfect time.
Sorry, yeah, so I think they've worked it all out perfectly, as I was saying. Judge Bankovenko?
Thanks,
Yeah.
thanks for that. Alice has, pick your metaphor, taken us down the rabbit hole, taken us through the looking glass. I find that in patent cases, when something happens at the Federal Circuit level, or particularly at the Supreme Court level, you get this trend of all of a sudden then that's the flavor of the day. And so we went through all those Twombly-Iqbal motions, and now every case has a 101, and of course IPRs are a whole nother thing. And I'm waiting for this trend to expire so that every case doesn't become a 101 challenge. I mean, if you subscribe to Docket Navigator, you saw that the lead case for weeks, for months, for years. It's all, the 101 yes, 101 no, 101 yes. And it's just been case after case. It's sort of getting a little bit more of a mix. There's been more damages leading opinions in the last couple of weeks, but it's a tough area, and it's hard for us. And I find it very difficult, frankly, because it's never just an isolated thing to just look at it and say, is this an abstract idea, and is it implement? And you've got somebody who's arguing they're applying it to my device in a way that's probably really an obviousness in 112 issue of it's either being read so broadly it's either obvious or it's not enabled. But I'm going to say that therefore makes it abstract because it's trying to cover every possible way of conceiving something. And it's hard to just sort of dice all that in your head and stick it down to just looking at what is it that's claimed here, and is it really an abstract principle, and have they added anything? And so much of this is computer stuff for me, and it gets very complicated. So it's not an enjoyable area.
So one more question on 101 is timing of motions. And so, obviously, a number of these motions get brought on 12b-6, but that raises questions as to the development of the factual record for preemption and conventionality. And so let me ask each of you, and I'm going to start at the other end of the table this time, to talk about your thoughts on timing and what you're seeing right now in terms of when these motions are getting brought and when they should be brought.
Well, when they're getting brought is as early as the defendants feel comfortable, and that tends to be a motion for judgment on the pleadings right up front. And then, if you just can't do it at that phase because there's been enough of a showing that there's a claim construction issue or it really requires outside the record, you've got to put it off. But I don't know when they're ever appropriate. I mean, the idea is supposed to be we want to do these as early as possible because if it shouldn't be there, you want to get rid of the whole case before all this work is done. On the other hand, you're asking a judge to do an awful lot to just read a patent and say, this is just not patentable. So I don't know when the right time is. Every case is different. How's that for an answer? Litigation is uncertain.
Certainly, every case is different. I have a sense that most often we're seeing them on 12C motions for judgment on the pleadings now, just in terms of if you counted them up. In the early post-Alice days, I saw them as late as post-trial motions. Cases that had, already had a verdict, but I was persuaded to let 101 into the case in light of recent case law developments at that point. And certainly we still see our fair share on a 12b-6 as opposed to a 12c. In terms of case management, the 12c poses an interesting challenge, one that I might need to talk to Judge Whyte about, because I have procedures, and many judges do, and of course there's the overlay of the federal rules. When a 12b-6 has to come in. We set in our schedule when a Rule 56 motion has to come in. You set a trial date, but a 12C just has to be filed enough in advance of trial so as not to throw off the trial date. And that really could be arguably almost any day from the beginning of the case till, let's say, the pretrial conference. And so it becomes a difficulty sort of when it comes in, planning and deciding, should I work on this or should I keep moving the case along as it was moving? And so that's just an interesting challenge we're facing now.
Judge Guilford?
Well, I have some strong feelings about 12b-6 versus 56. I read somewhere that a pleading need only be a short, plain statement. Where was that? Oh, yeah, the Federal Rules of Civil Procedure, Rule 8, says a short, plain statement. We then had Iqbal and Twombly, and we had the Bill of Lading case coming out of the Federal Circuit, and we were looking at the form, and the form seemed to imply pretty plain and simple. And then the form got repealed, but the repeal said this doesn't have any substantive effect on the pleading standards. So it seems to me that there's a lot of tension here. And the tension is between quickly closing the door to the courthouse before all the expense and all of that that we've decided, that we've already identified, or allowing a case to more fully develop with merely a short, plain statement. So when it comes to Rule 101, I am wondering about really whether 12b-6 is an appropriate vehicle to get rid of the case that early. And I struggle with this. I will say, particularly here to California lawyers, you know, the state system in California, 437C, requires a lot of other things in a summary judgment motion. I think to protect someone's right to a jury trial and to really assure whether or not there's a factual issue. And you know, we have the separate statement under 437C. Most of our local rules in federal court in California also has a separate statement requirement in a Rule 56 motion. Why do I say all of that? Well, I say all of that because Rule 56 is very careful about when it kicks someone out of court. And I think we should be cautious about that, maybe more cautious in jurisdictions like those in California that have all these extra rules under Rule 56. A separate statement of undisputed facts and all of that sort of thing. And so I'm hesitant to grant relief at the 12b-6 stage. That's a very early time to shut the courthouse doors on someone. And I know there's a lot of political considerations about expense and trolls and all of that, but I still come back to Federal Rule of Civil Procedure 8, a short, plain statement. Now, moving further on the issue of pleadings in a 101 context, some of the recent cases I've seen coming out of the Federal Circuit suggest to me that any decent plaintiff lawyer ought to be able to include allegations in the complaint that will overcome a 101 attack. Allegations going to some of the key features, going to the 2 steps of Alice. I mean, you can just state in your complaint the appropriate allegation concerning abstractness or inventiveness. And if we're true to a 12b-6 standard, we should accept those allegations. Now, the response might be, Rule 11, you can't be alleging things that aren't so. But I think our whole discussion of 101 and Alice is that these are kind of subjective determinations on inventiveness, step 2, abstract, step 1, that you're not violating Rule 11 by making your statement as to non-abstractness in your pleadings. And if you do that, I think you can avoid an excessively early 101 ruling at the 12b-6 stage. Still, when I became a judge, I swore to apply the law, and the Supreme Court gives me the law on Iqbal and Twombly, and I'm still trying to reconcile that with Rule 8.
So Judge Guilford pointed out to me that I forgot one question on 101 that I did want to ask, so that wasn't my last question. And this one is, what is the most challenging aspect of Section 101 for you? And since Judge Guilford pointed out that I skipped it, I'm going to ask him first.
Okay, well, you know, here's 101. As a district judge, we see the Federal Circuit, and I really respect what the Federal Circuit tells us about patent law, and I try and do that, and then it goes up to the Supreme Court, and I have to wait around to see what the Supreme Court does. Well, in Alice, of course, they gave us the rather unbright line test of a 2-step process. So I'm dealing with a 2-step process in a case out of the Supreme Court, and the frustration to me is in the largely commercial area of patent law, I'm a big fan for bright lines, and I don't see very many lines that are bright in the 2-step process. In fact, as I just suggested, man, so much of it is subjective. And when I consider in the commercial world how much money has been invested in certain patents, which are now totally subjected to such a subjective 2-step analysis out of the Supreme Court, I am frustrated. I started earlier saying I got the CPU and I'm processing facts to make a determination, abstract or not abstract, and I guess part of that is me trying to find some higher level of predictability in an Alice 2-step process, predictability that will provide funding and all the things that the commercial world does.
Judge Stark?
I'm not sure that I'm seeing 101 as necessarily particularly, more challenging than other areas of patent law or other areas of civil law in other complex cases that we're handling. But I'll tell you, one of the interesting features of 101, at least over the past 2 years, maybe it'll be less true going forward, has been how many cases are coming down and knowing that more cases would be coming down. So, for instance, I've had many early post-Alice 101 motions where we had to decide based on maybe one data point at the time. And you knew by the time, A, you knew this is going up to the federal circuit, just given the nature of it, and B, it's going to take 12, 18, 24 months before the federal circuit decides it. And who knows where the law is going to be and what the data points are going to be between now and then. And so I'm not whining about that. It's actually kind of neat, I think. But, to some extent, you had to not just apply the law as it was at the time, but think a little bit about what's this going to look like maybe, down the road once more of these cases work their way through and my analysis is actually being assessed by the Court of Appeals.
Judge Benchavengo?
Yeah, I think one of the hardest things about 101 is that there are usually really good lawyers on both sides arguing a very persuasive point of view, and I have to ultimately make a decision. And so, if you grant a 101 motion, it's obviously going up on appeal, especially if it's early. And so you just take your chances and you say, well, I have to make a decision and I may be right or I may be wrong on here, and this is, as you said, the best set of data points I have right now. And I think it's helpful that that landscape is filling in, and there are, not just in this particular instance, but there are lots of times you make a decision on something and then 2 years later you look back and go, I might have decided that differently if I'd known then what I know now. So that makes it hard when you're in an area that's growing immediately, and the lawyers are very enthusiastic on both sides.
So I'm going to shift gears now to another area that's obviously very much in flux and has changed over the last few years, and that is Octane Fitness and attorney's fee awards. And the question I will pose to start the discussion is, what exactly is the standard right now, and how are you thinking about that? And do you have any guidance for the litigants that are presenting these motions to you? And Judge Stark, I'll start with you this time, if I can, and let you just sort of riff on attorney's fees for a minute.
I thought I was safe in the middle here. But, well, we're seeing a great deal of these motions, of course, and I think ultimately the test is the case exceptional, and we saw one of Judge Whyte's examples of what does that mean, and I think it's a case-by-case analysis. I don't think I have any clear-cut sort of view as to what for all cases will make a certain case exceptional or not. Some of the interesting things that have come up on my docket, and I imagine are an interesting challenge for litigators, is we have a great deal of patent cases in Delaware, and so I think I have still about 250 on my docket today, and so for something to stand out as exceptional, like literally a case that stands out and that I actually remember, by the time I'm analyzing your exceptionality test, like that, it really has to be exceptional in some way, right? So, but not every district judge you're going to try a case in front of, a patent case, is going to have that same, number of cases, and so your case may stand out, for the rest of their career because it's one of the only patent trials they've had, and so maybe the standard is different for that judge. The other interesting sort of iteration that I feel like I'm seeing, but I'll never know for sure, is how many of the little sort of, let's call them landmines, that are being planted throughout the 2 to 3 years leading up to trial are there so that consciously or not, if the side prevails at trial, they can argue after trial, this is what made the case exceptional, or I gave them an off-ramp, maybe it was a 101 motion, and let's say the plaintiff had a chance. I put all my cards on the table, I had an excellent 101 motion. They should have somehow seen that even though they maybe weaseled out of that, they were going to lose in the end for whatever reason. And so at least everything after that motion is should be compensable to my side, because I let them know as best I could that they were going to ultimately end up in a bad place. So, we get a lot of arguments about those sorts of issues.
Judge Benjamin?
I agree. I thought it was interesting when the standard got articulated in terms of saying, well, what the judge would find exceptional in their experience in their court. And so, yeah, if you've got 250, or if you're Rodney Gilstrap and you've got 650 patent cases, to stand out as exceptional would be interesting. If you're a judge who's seen one patent case in their whole career, the whole process may seem exceptional to you. And and I know from the lawyer's point of view, much like our children, we all think our cases are exceptional. So you've got, so everyone wants to, I think clients have an expectation when they win that you're going to bring a motion for fees, because obviously they won because the other side was frivolous and in bad faith. And a lot of those motions I don't think are well taken. And we are seeing them much more frequently, I think, than you did in the past. I know that there are times when you can, I think, send signals to people in your order, granting a motion for summary judgment and describing it as a close call. Should be a signal perhaps to the lawyers that this was not a slam dunk, and that they, maybe a fee motion's not going to be well received. Or the contrary, there was no basis whatsoever for this claim that the plaintiffs made. Come on, bring the fee motion. So, it's interesting. I do think we see a lot more than we would have in the past, and I still think that when you look at the cases, the reported cases on it, people are still looking at really bad faith conduct, unmeritorious claims, not just you won, so bring your fee motion.
Judge Guilford?
Well, I note that Judge Whyte's decision, I think, was 2009. I quickly looked to the date. It was pre-Octane, which leads to the question as to whether Octane changed the standard very much. I think it tended to do that. It's interesting, so far we've talked about Alice, and I mentioned Iqbal Twombly, and we've talked about Octane. And these are all interesting decisions from the Supreme Court, which may partly be reflecting a little bit of political reality. Policy questions. As a district court judge, of course, I don't get into policy, but when I review exceptional, I wonder if the Supreme Court wants me to award attorney fees more often to get rid of those doggone trolls. Okay. Something that again, I don't think it's my job. I'm applying the law. So getting to exceptional, what does exceptional mean? I was a trial lawyer for 30 years, and I kind of take maybe a holistic view. Potter Stewart view. I know it when I see it. And the comparison between Potter Stewart's view on pornography and my view on an exceptional case might have some comparisons there, because, boy, attorneys do some things out there that perhaps deserve to be disciplined with an attorney fee award. Setting a deposition date on July 4th and insisting that it not be moved. Is that exceptional? And is the setting of a deposition date something that you consider in determining exceptionality? Again, I take kind of a holistic approach. I know it when I see it. But then getting to the broader policy question, there's the English rule and the American rule, and is this view in Octane the camel's nose of the English rule under the American rule tent, and where is it going to go, and how do we feel about loser pay rules, which essentially is what's going on here. Again, I try to apply the law and not get into policy too much, but I think on a policy level, there are some intriguing questions about whether we want to be more vigorous in the imposition of a loser pay rule and the commercial context of patent law. Some might say a loser pay rule is inappropriate in a contingency fee broken arm case, but maybe much more appropriate in a battle between commercial giants. So these are all some thoughts that go through my mind on determining whether something is exceptional, and I think fundamentally I come down to kind of a holistic approach. I know it when I see it.
As a practical matter, though, if you think your case is heading toward an exceptional finding, that's part one. then you have to make your fee application for what's still reasonable and necessary. And I am surprised at how many times I have seen fee applications, not necessarily in patent cases, but in any fee application case. And I've seen decisions on Docket Navigator where fees have been severely cut or denied because of the failure to properly present them to the court. I mean, if you're heading in that direction, take the time to think about what you're going to present, and you can't just say, well, I'll present it in camera and you figure it out. That's not how it works. And so, documenting even your costs. People have been denied costs because they didn't have proper receipts. I mean, in the context of, if you want to get your fees, you better make sure you're going to give me a good record to award fees on.
And then Judge Guilford leaned over because he had a reaction to that. And so reasonableness.
Okay.
So give us some thoughts on that.
Real quick on reasonableness, again, I prefer a holistic approach. My clients, when I was a lawyer, didn't complain too much about my billing rate. They complained about a $50,000 12B6 motion. And I think lawyers who become judges, and judges in general, having observed how a case progresses, have a general view on what are reasonable fees. And just quickly, I'd like to say that 2 Supreme Court justices have kind of confirmed the notion that we judges don't need to put on eye shades and become accountants and determine the fairness of every hour at every reasonable, allegedly reasonable rate. In fact, Justice Kagan said, district court judges need not and indeed should not become green eye shade accountants. The essential goal in shifting fees to either party is to do rough justice, not to achieve accounting perfection. So trial courts may take into account their overall sense of a suit and may use estimates in calculating and allocating an attorney's time. When Octane came down, one of the initial reactions was, oh, district judges will have a whole cottage industry of determining reasonable rates times reasonable hours to determine an appropriate amount. I'm concerned about that allocation of our time post-Octane, and I would suggest the solution is in some of these decisions which suggest we are not green eye-shaded accountants, but we can take more of a holistic approach on what would be reasonable in a particular case.
So one of the things that's sort of threaded through a number of these topics is how patent reform efforts at Congress or some of these very high-profile Supreme Court cases are impacting the way that district court judges are looking at cases on the ground. So I want to shift a little bit and just spend a few minutes talking about the AIA and its impact for each of you, and then we'll transition to talking about the 2015 rule change and how that's impacted you. Judge Benchavango, the AIA, how has that impacted practice in your courtroom?
Well, the biggest, obviously, is the IPRs. I mean, and so you start immediately, the case gets filed, and within the requisite time period, in almost every case, you get a petition to stay because or you get a motion to stay because they've petitioned for review. And deciding the when and the where of that and how it's going to work and how many claims and how many patents are affected and how efficient it's going to be to stay or not. And it is, again, it's going to be a case-by-case analysis, and so it's not always helpful to say, well, the rule in this court or in this district or in this, because there's no real rule. Every case is going to be evaluated individually as to whether or not to stay. My one unfortunate experience with the decision to go ahead with parallel proceedings when the motion to stay came rather late and I'd already done claim construction, resulted in motions for summary judgment being filed based on my claim construction, and then while the motions were still being briefed and being ready to be heard, a decision came out on the IPR to deny it, but I then got supplemental briefing of statements that were made in the IPR to avoid the invalidity analysis that changed the claim construction significantly from what I had done based on the positions the plaintiff's expert had taken in front of the IPR. So they had to rebrief the whole summary judgment because there was a whole new set of facts to deal with. And that was not, I think, an economic, ultimately, way to proceed. So it's hard. The other AIA problem that I thought was a big problem when the rules first came out, the non-joinder thing, I think the courts have sort of ironed that out by creating what have essentially become little mini MDLs. When you file your case, your 50 patent cases, that's the one plaintiff and 50 separate defendants, they're getting low numbered to the lucky judge who got number one, and you're getting all of them. And so you end up then, I think, doing case management that encompasses the whole group and tries to figure out the best way to divide up the patents and the claim, and so you do one claim construction and not in, multiple cases. And so we've sort of worked our way around that problem, but it's still out there.
Judge Stark?
Yeah, and I think, so the AIA, I think, has mostly had impact through the IPR, as Judge Banco said, and it impacts us usually in 3 different stages of the case: the request for a stay, at claim construction, and then on preemption. And anecdotally, my experience has been in the first few years, it was really a lot of litigation over stays and whether or not we should stay. For whatever reason, I haven't noticed as many disputed stay issues lately. And although I anticipated preemption might pose some difficult issues, particularly in the cases where you had some defendants who were not formally part of the IPR and therefore were not formally estopped in the same way that the petitioner in the IPR was, I haven't really had too much litigation over that. Now, that may be in part because what often happened at the stay stage was parties realized that they were more likely to persuade at least me to stay a case if they could clarify for me what the preemption impact would be if and when the case came back to me, which meant we got a lot of sort of stipulations and agreements that even though I'm not statutorily estopped, because I'm not a petitioner in the IPR, I will agree to be estopped to the same extent as those who are statutorily estopped. As a result, where we're mostly seeing the litigation, at least I am in my courtroom, is at claim construction for whatever reason. So very commonly, certainly if I haven't stayed my case, we get a lot of briefing, either hopefully with the initial Markman briefing, but sometimes depending on timing it comes in as supplemental briefing on, but you said this to the PTAB, or the PTAB said that about claim construction, and now you have to defend or account for those statements in that parallel proceeding and factor it in through the district court standard, which is obviously a different legal standard, and it adds some complexity to figuring out how to apply the district court standard to claim construction in front of us. One argument I've seen many times now, it's one that defendants are facing, is they'll argue for indefiniteness, and the plaintiff will turn around and show me what they argued at the PTAB. And at the PTAB, they were quite clear on what the scope of the claims were and just how invalid they were. And then they come in to district court and say, but it's indefinite, it's, there's no reasonable certainty whatsoever. And you can harmonize those things because there's usually excellent lawyers on both sides of these cases, but it's just, a challenge that may not have been anticipated when the party chose to petition for an IPR.
Judge Guilford?
Well, I think in the AIA, the people of the United States of America made their will known through Congress, and part of that will was that IPRs are the thing of the day and that we should implement this review by the IPR. And so when the stays come up, I think generally I should grant the stay and let the IPR make the determination, and that's what I do most of the time, but not all the time, because somewhere I read that I'm supposed to provide a just, speedy, and inexpensive determination of every action. Federal Rule of Civil Procedure 1, these pesky federal rules coming out here. And in determining how best I can provide a just, speedy, and inexpensive determination, at times I am frustrated by how many balls are in the air. The IPR is one situation. I grant the stay and it comes back much, much later and it complicates things and the case remains on my docket. And another situation, of course, is oh, stay the case because the Federal Circuit is about to make an important ruling on this precise point. And of course, sometimes I do that. Oh, and then it goes to the Supreme Court, and so there's another year. At least the Supreme Court, it's usually only a year delay because they get their cases out. But I find that as a district judge, I spend a lot of time waiting on the IPR or waiting for the wisdom to come from the Federal Circuit, only to find out that now I've got to wait on the wisdom to come from the Supreme Court. And I at times have trouble reconciling all this with my charge under FRCP 1. So I grant stays usually, not always, and I honor the IPR proceedings, and I can see it's provided some benefits, but I have to say as a district judge, at times it provides some frustration managing my docket.
So I have one more question about rule changes, and then I'm going to go to some practice tips and things for the audience here. But that question is, when we were talking and planning for this, some of the judges remarked that they have not seen an increase in 12b6 motions, notwithstanding the rule change last December. And so I wanted to get your experience, each of your experience with that, and your thoughts on maybe why that's not happening or whether it should be happening more. And I'll start with Judge Stark on this in the middle.
Sure. Sometimes I worry that I'm tempting fate when I say things like this, but I expected I would see another explosion of 12b6 motions after the change in the rules last year and the elimination of Form 18, and I've not seen it. And I think with hindsight, even though I would have predicted incorrectly, now it seems clear to me why that hasn't happened, and I think in a real way it goes back to Judge Whyte, because if you're not getting what you need in terms of the full sort of claim by claim or element by element detail that you might otherwise think you should have in a complaint, under the rules here in the Northern District of California or under specific procedures that I tend to follow in my cases, you're going to get that kind of level of detail fairly early on in the case. And so my guess, of course, I don't know, you all could tell me, my guess is decisions have been made rather than file a 12b6 in order to get that extra detail. The energy is maybe going towards let's get exchange of contention interrogatories, for instance, schedule that we can live with. And if I don't get the sufficient disclosure there, I'll bring a discovery dispute and ask the judge to rule that they need to supplement their contentions. So that's where it's coming out. And again, I think it is credit to the regimes that are out there under the local rules or the case management practices many of us follow. You're going to get that type of detail you need, hopefully early enough for it to be meaningful.
Judge Benjavengo, anything to add to that? Any different experience on your side?
Yeah, I have not seen motions for 12b6 motions on direct infringement. We still see them on indirect infringement allegations occasionally, but they haven't come up. And I do think it's largely because, you're going to get your infringement contentions shortly after. And I would hope that the rationale is that, in judging how you want to spend your time and your client's money, bringing a motion to get a more, specific statement in a complaint when these infringement contentions are the next thing up is not really the most efficient way to progress the case and spend everybody's, resources. And I think plaintiffs have largely responded by being a little more specific in the complaint by saying, it's these claims of this patent and this is a product that we claim it covers, and while they don't then do a claim chart within the complaint, you've at least got claims identified as opposed to just a generic, we own a patent and you infringe, and there you go. So there's been, I think, on both sides enough of at least what I've seen so far, of a compromise that no one's pulling the trigger on this one readily. My next case will probably have a motion to dismiss, but.
Judge Guilford?
Well, the Form 18 carve-out of Iqbal and Twombly rules was kind of an odd creature. With all the competing statements that Form 18 is consistent with Iqbal and Twombly, or it's not consistent with Iqbal and Twombly, or Iqbal and Twombly does not apply in a Form 18 infringement situation, but it applies in other situations. And I think lawyers were just kind of taking a deep breath to see how it all comes out. And with the repeal of Form 18, at least there's something consistent about across the board. And I agree with what my two colleagues here have just said, that the local rules, thanks to Judge Whyte here, have made the Iqbal Twombly conversation far less important. And I must say, listening to my colleagues is helpful to me. I really enjoy these panels. I remember sitting out there hearing Judge Whyte carry on like this. And now I'm sitting next to champions of the area and learning from them and what they say. And I think they're kind of nailing it, that the local rules, which began in the Northern District through Judge Whyte, have gotten us past, I think, some absurdities arising from Iqbal and Twombly.
So the last question I have is, you have a captive audience here of a lot of frequent flyers in your courtrooms. You also have some Federal Circuit judges, and so I will ask each of you, if you have feedback for the litigants and lawyers that appear in front of you, advice or pet peeves, or if you had feedback for the Federal Circuit judges that are here, or both, I will leave it to you to make a decision as to which of those things you want to answer. And I'm going to start with Judge Benchavango.
Lucky you.
Lucky me. I love patent cases. I did patent litigation for 17 years before I got on the bench, and now I've been doing it for 10 years on the bench. And I still, unfortunately, have tried more patent cases as a lawyer than I've heard as a judge. But I think that's because I grant summary judgment a lot. I think patent lawyers are very hardworking, and they're very bright, and they're very dedicated to their craft, and that's why I enjoy working with you. I love learning about new technology. I can never stress enough that, any opportunity you have to teach me about the technology you want me to rule on, you should take advantage of. It's surprising to me on the occasion when someone comes in and just doesn't. I know we're doing claim construction and it's not necessarily about the accused device, but it is. So bring it, show it to me, tell me what it does, tell me why it's important, teach me what the problem was that the invention supposedly solved, or why your product doesn't infringe. It's such a great teaching opportunity because you're dealing with technology, and technology can be fun. And I like pictures and models and toys, the glow-in-the-dark rats when we had the, the jellyfish thing that they put in to make the cancer tumors, and they brought the little mice in and you could see them in the dark box and they glowed. It was very cool. I think it's a great practice area if you have show and tell skills to really use them, and I always encourage that. There's that unfortunate reputation that people have that it gets a lot of bickering, and because a lot of money's often at stake, that people fight over the small stuff to unnecessary degrees. And I think that's a case management issue, both on the part of the court and on the part of lead trial lawyers, to make sure that their associates haven't run amok and are litigating every little issue like it's, World War III, and keeping their eye on the ball. I think it's sad that not that many cases go to trial, because they're great experiences for a lot of people to learn how to try a case and be part of a trial team and see some really excellent lawyers try cases. And I do think juries can handle patent cases when they're properly presented, and there's, you're teaching, again, it's a teaching tool. And they try really hard and they work at it really hard to do the right thing. I just kind of keeping your eye on the ball, preparing your case for purposes of saying, yeah, chances are it's not going to go to trial, but the best way to prepare it in accordance with Rule 1 is to prepare it like you're going to take it to trial. Do the discovery you need to do to prove your case or defend your case. Get it done. Be prepared. Bring the motions you need to bring. Don't bring summary judgment motions to teach me about the case. Bring summary judgment motions because you think it's something that can be resolved. And I don't know. I'm not going to be more specific than that. Go ahead.
Well, that's more specific than I'll be. So I'm tempted to dodge the question entirely and just, again, thank Judge Whyte, which he well deserves. What comes to mind is really the same thought that I would express to a room full of experienced patent litigators and to the federal circuit, and it's not something that you don't all already know, but it doesn't hurt, I think, to repeat it since I've been asked. It's just to understand what it's like to be a district judge who has to handle these cases, because certainly in my court I have a great deal of them, but it's not the only thing that I'm doing. And my colleagues who have maybe fewer of these than I do, they have a lot of other things too. And so your cases are very important, they're very interesting, but they're very difficult. They're time consuming. You have to learn the technology. That takes a lot of time and effort and hard work. The law is constantly in flux, as we've talked about for an hour and could talk about for many more hours. So that takes a lot of effort and time to learn and to apply. And you're very litigious, and so there's a lot of things we have to do to manage a patent case from beginning to end, and again, it's not the only thing by far that any of us are doing, and so as litigators, I think it's important to understand that and to pick and choose where you really need to emphasize and get the judge's attention, and to be super prepared and to boil things down to a way that we as lay people can understand what we need to understand. And on the back end, I think and hope that the federal circuit judges reviewing our work understand that these things, again, are complex. They come up and you have to make lots and lots of decisions in real time, almost never with as much time and ability to think through as you might like to have.
Judge Guilford?
Forgive me for repeating what I've said at other programs like this, even in this room. The job of a trial lawyer is to bring simplicity out of complexity, to bring order out of chaos. The way you do that is through themes, through joining together concepts into simplifying themes. That's really important to a jury, and it's even important to district judges. So, don't tell me about the billions and billions of stars. Tell me about the constellations. Create themes that push your case forward. Don't tell me about all the trees in the forest. Tell me about the forest. And in the process, save a forest of trees in your paperwork that you've presented to me. Bring order out of chaos. Now, patent lawyers are brilliant, and brilliant people tend to be detailed people. And brilliant people who love technology tend to love the technology and bring, at times, chaos out of order and explaining every detail of the technology, every tree, instead of coming up with the important unifying themes, the constellations and the forests. And with that, I think I'm the only thing between us and lunch, so let me again thank Judge Whyte and
And thank you to the whole panel. Thank you.